Hey y'all, Professor Tracy back, this time with a video on the parole evidence rule. So we finally finished all the lessons dealing with defenses, the defenses to formation, and then the changed circumstances defenses. And now we are looking at this bigger question of what are the terms of our contract. If we have a contract, how do we determine what the terms are, where they come from, and how do we understand those terms or interpret those terms? And keep in mind that it's only when we understand the terms that we can properly determine whether someone has breached, right? Until we understand what exactly the obligations of the parties are, what their duties are to one another, we can't determine whether they have fulfilled those duties or not, which is why we're taking it up now before looking at the concept of breach. So let's look right to it and set up this basic or typical factual scenario, which is the general situation in which this parole evidence rule comes up. And as I said at the outset, one of the things we're looking at is establishing the terms of the contract. The parole evidence rule is a rule that is aimed at saying, where should those terms come from? From what evidence can the court or the finder of fact, what can they look at to determine what the terms of the contract are? And in particular, in this kind of setting here, with the typical factual scenario first, requiring that the parties have reduced their agreement, their contract, to writing, meaning they've reached an agreement, they've memorialized it in writing, and that writing is going to now obviously serve as evidence of what they have agreed to. And what will typically happen when the parole evidence rule comes up is the second thing in the typical factual scenario is that there is some sort of dispute that arises. One of the parties will be contending that the other party didn't do something that they were required to do or didn't do it the way they said they would do it. And now one of them is going to say, okay, but that's not in the contract. Our entire agreement is listed or contained in the writing that we established, that we wrote out. Our entire agreement is there. That's where all of our terms are. And the other party is saying, no, we orally agreed either before they executed, reduced everything to writing and executed the written agreement, or as they were sitting at the table executing it, there was some oral understanding or agreement that was reached, and that party's contending, well, remember that we said this or we agreed to this other thing. And the other party's saying, no, it's not in there. It's not in the written agreement. Had we agreed to it, surely we would have put it in the written agreement. And so that's how we end up in this situation where we have to decide, well, what do we do? Do we stick by and say, well, there's only the written agreement should be considered, or do we allow evidence of this alleged oral agreement or understanding to come in to evidence? So let's put some meat to this as we look at things here and look at a more concrete example. So let's assume that I own a hotel. I'm going to sell that hotel to you, and I say to you, I will sell you my hotel, including the furniture, for $2 million. Now we're having an oral discussion here. And then you say, okay, but can I have a year to pay the purchase price? And I say, sure, that's not a problem. Let's have the lawyers draft the agreement, and you are readily agreeable, right? You say, great, sounds good. And there we have an oral agreement, right? If we were to just look at it now, you are agreeing to buy my hotel with all of its furniture for the price of $2 million. You're going to have a year to pay it off. That's the oral agreement that we entered into. And so we can see it there laid out here, the oral contract between me and you. I'm giving you the hotel and with the furniture, and you're going to pay me $2 million over the course of 1 year. You have to pay it off. And so the lawyers get to work and they are preparing this agreement. And there it is in all of its glory, and I sign it and you sign it. And so we have a written agreement, and its terms say this. They say, I, Tracy, hereby agree to sell my hotel to you for $2 million, amount to be paid by you in 6 months. Signed Tracy, signed you. So it should, as you look at this, a couple things strike you that are not actually here or are different than what we orally agreed to. That the writing, if we look at that, we can say, well, it's missing the 2-year term, right? It says 6 months, right? Or it's missing 2 terms, not 2-year term. It's missing what? The furniture. It says nothing about the furniture in the hotel being sold with it. But what we orally agreed to mentioned the furniture, and we orally agreed to 1-year term, not 6 months. So if we look at this, then the written agreement looks like this. It says, I'm going to give you the hotel alone, no mention of furniture, and you're going to pay me the $2 million within 6 months only. So if we compare and we look, say, this is the oral agreement and this is the written agreement, then we know these are the differences. That orally, it was the hotel and the furniture. In writing, it was the hotel alone. That with the price is the same. That didn't change in this transition, reducing it to writing. So, but the time period for paying it off did. Orally, we said 1 year, and yet the written agreement says only 6 months. So when we look at this then, let's assume that we perform. And so despite the fact we have this discrepancy, there's a written agreement, and then I am complying with the written agreement, right? I'm saying, here's the hotel and no furniture. And you're saying, I'm complying with the oral agreement. I am paying you $2 million over a period of 1 year. And so when we look at this, you sue me because there's a breach, right? You're saying, well, there's no furniture. You orally said you would provide the furniture. I'm suing you because you're taking more than 6 months, right? The writing says 6 months, and you're going, but we orally said a year. So I'm saying, well, I'd prefer to have my money earlier. So here, obviously, everything favorable, assuming I really do want the furniture from the hotel, then we can say that the written agreement helps me because it includes no furniture, right? I'm having to give you less, although to be fair, in real life, I would have to deal with, I would have to find something to do with all that furniture. But, and that you have to pay me sooner, in 6 months rather than a year. So it helps me in this particular case. And particularly as I performed, it covers me entirely, right? Because I didn't give you the furniture. So that's great because the written agreement doesn't require that. And I would like my money earlier. So I'm suing, saying that I would like my money within 6 months, not within a year. But so if all we had around was the written contract, and it is from that we definitely draw all our terms, then that would mean that I win, right? Because everything I want is consistent with the written agreement. But we have this oral agreement out there, and that obviously helps you because it includes the furniture which you want, because if you're going to use it as a hotel, you either want the furniture to come with it, or you've got a plan to pay for it. Obviously, that would be a large expense in addition to buying the hotel itself. And you would prefer to have a little bit longer time, and well, not a little bit longer, double the time to pay it off. So the oral agreement is consistent with what you would like to occur. So if you can get this evidence of this oral contract to come in between you and I, then you have a chance of prevailing. But absent that, I'm going to win. So you then are going, here, court, is evidence of the oral agreement. So you're offering this evidence. Keep in mind the situation. This fits the typical fact pattern that we have a written contract, you and I, and that there's a dispute that arises. I'm insisting that the written contract that's our agreement. That includes all the terms that we agreed to and what they were. And you're saying, oh, no, there was an oral agreement that was before that preceded that written agreement. So that's your argument. And so the question when we're faced with a parole evidence rule is, what do we do in this kind of situation? It's great. We now kind of see how the typical fact pattern works, but how does a court decide? And the parole evidence rule is what comes sweeping in here. And we want to ask ourselves in situations like this, well, do we in fact have a parole evidence rule problem? Is this a parole evidence problem or issue? And the answer is we have a written contract. It is this situation, as we just said, one party, me, Tracy, is claiming that all the writing contains all of the terms, and you, the other party, are claiming that no, there's also this oral agreement we had that pre-existed the written agreement, and it should come in, evidence of that should come in as evidence of what the terms, either what the true terms of the agreement are or as additional terms. So we definitely have what looks to be a parole evidence rule issue. So we have to go to step 2, so we look at and we're applying here just the first step, right? We said we have a written contract. I'm claiming the writing. You're claiming the oral agreement. We've said it now 3 times. So we're pretty clear on it, right? So let's go to the second step which is we're now going to examine the writing itself to answer the question of whether you can get evidence of the oral agreement meaning in the record, then and if we're having a trial, then considered by the finder of fact, that kind of thing, then the court needs to look at the writing, this alleged written contract, to say, well, what is it? What level of integration is it? And to say that, we're asking, was it intended by the parties to be final? Was that the final, meaning the final expression of our agreement, of our contract? And 2, if it was intended to be the final expression of our agreement, was it intended to be a complete expression? Meaning, did we intend it to encompass all of the terms of our agreement? We intended it to be the complete expression of our agreement between you and me. And so to say final, it is this. Is it the final expression of that? Now, to be fair, this is written in I guess a more accurate way than what I just said, which is to say, when we're asking final expression, it is quite possible that a court will say, well, at least part of this appears to be a final expression of the terms that are there, but maybe not all of it. And we'll talk more about that. So that's why it's said one or more terms. It doesn't necessarily, it doesn't have to rise and fall entirely together, right? All of it. So complete means, is it the kind of thing that you and I intended to encompass all our terms? As we said, a complete expression. But we now have to ask, well, how does the court even know that? What does that even mean? Those are nice words, and maybe you think you understand what they mean, but should be this burning question, which is, how do I have any idea how to determine if it's final, if it's complete? There are 2 approaches, which is great, right? Because already a somewhat complicated technical topic, we're going to complicate even more by saying, well, realistically, when courts are doing this, there's a split. Jurisdictionally, there's a split. So there are 2 approaches that have arisen. And I am going to call them classic and modern. You might hear them called different things like Four Corners or Williston and Corbin or whatever. I'm calling this a classic jurisdiction. It's sometimes called the Four Corners jurisdiction. What it means is that the court's only going to consider the writing itself when it's assessing, right? What you might say, like, what are you doing here, Tracy? I don't understand the context. What these approaches are getting at is when the court is looking and saying, should we treat this written agreement that the parties are offering, that I am doubling down on, Tracy, am saying, this is it, this is everything about the sale of the hotel to this other dude, then there is this question when we're looking about how much weight should we give to the writing? How important is it? Should we treat it as if it is it? That is what was intended to express their agreement. And to determine that, there are 2 approaches that courts follow. One is called a classic jurisdiction or a Four Corners approach. Another is called a modern jurisdiction. And it's a sort of all the fact, consider all the surrounding facts and circumstances approach. So what the courts are doing is they're going, we're going to assess this writing to decide what it is. But the question is, in assessing it, to determine, is it final, is it complete, should we treat it as an integration, they are going to say, what is it they should be looking at? In a classic jurisdiction, the answer is the only thing they should consider and will consider is the writing itself, and to determine, did the parties intend this agreement to be the final and complete expression of their agreement? And so that's what they're doing, right? They're looking at and going, is it final? Is it complete? They're assessing it, but only looking at the writing. And there might be a merger clause, get it clause, haha, Santa Claus, merger clause. Yeah, it's funny, come on. So here, this is in a classic jurisdiction. If there's a merger clause or what's also called an integration clause, then that will be dispositive, because we're looking at the writing itself, and that's all we're assessing. And so if the parties themselves have included a provision in the agreement saying this is the final and complete expression of our agreement, which is what a merger clause or an integration clause is, it's dispositive, meaning it determines the issue. You're done. If it says that, then we'll see, yes, it's an integration, and in fact, it would be called a total integration or complete integration. So that, and we'll see, well, who cares? What's the effect of that? Well, we'll get there. The other approach is a modern jurisdiction. As I mentioned, we're looking at the entire context, the entire world surrounding the execution of this agreement. Are we considering the writing itself also? Absolutely. That's one of the things we're considering, but also all the surrounding facts and circumstances. And we're still asking the same question. Is the writing final? Is it complete? We're still assessing for that reason. And then there's got a merger clause. I mean, it's not a clause, but still Christmas. See, still funny. So here, instead of the merger or integration clause being dispositive, it only raises a presumption. It only raises a presumption that the writing was intended to be the final and complete expression of the parties' agreement. So it is not conclusive any longer, or so in that way, it can be rebutted by other evidence. So when courts are doing this, regardless of what approach they're following, and keep in mind, the majority approach at this point is the modern approach. And the classic approach being the older approach and the minority approach. So here, there's three, when a court is assessing using one of these approaches, there's three possible outcomes. They could decide, I think this is a total integration because it appears to be final and complete based on all the evidence, right? Or it could be final and incomplete. And keep in mind, whether you might say, well, what's final and incomplete? Doesn't make sense. It does if you stop to think what we're saying. We're saying what's there, the terms that are there are final. But it doesn't include all the terms. The terms in the writing appear to be the final expression of those terms, but they are not every term is there. And so, therefore, it's incomplete. But there are various reasons we may land on the position that a writing is partially integrated. But the effect is to say we have some of the terms, those are final, but there are other terms that could exist that may be admissible. And we'll look at that more detail in just a second. And then you could have a court look at the writing and go, I don't even think this is a final expression of those terms. So maybe it's a draft of some possible writing that the parties were kicking around, but it was never intended to be a final expression of any part of their agreement. That this writing, whatever it is, was not intended to be the final expression of any of their agreements. And for that reason, we don't even, we're not even going to look and go, is all of it there? Because we've just said, whatever it is, none of those terms are final. So it doesn't matter. It's certainly not going to be any version of complete or incomplete, because it's just like, well, it's there. It can, maybe the writing can come in as evidence, but it probably isn't worth a lot of weight because it appears to just be something that was, considered, kicked around, a possible draft, but not any sort of final expression. So regardless of the outcome, right? Regardless of the outcome we look at here, where we go, it's fine. If the court goes, it's total integration or it's partial integration or it's not an integration, we still need to answer the question of, is this evidence, and in our particular example, that you were trying to put in, of an oral agreement between you and I that has a provision about the furniture, which is that term, and then the term about the amount of time to be paid, that it's actually a year rather than 6 months, right? Rather than what the writing says, which is 6 months. So regardless, we still need to decide, well, okay, we're not done. Whatever bucket or category we put this written agreement that you and I have in as total, partial, or not integrated, we ultimately would still need to go to step 3. So let's apply what we just said and assessing what our agreement is. So how do we do that? Well, if we're in a classic jurisdiction, remember, we are just looking at the writing itself, and it doesn't say anything about a closing date. If we were to say what kinds of things are missing, it doesn't really describe the property. It just talks about my hotel. It includes the price, and it includes the payment date. If you're looking at that, there are terms that are obviously missing that you would look at that and go, man, this doesn't seem like everything you would expect to be in there is there. So it is likely that this is just a partial integration. What's there? Maybe it looks to be the final expression of that term, but it doesn't appear to include everything. So that would mean it's a partial integration in a classic approach where we were just focused in on the writing itself. Now, in a modern approach, if we're going to apply that approach, we would look at everything we just said about what's in and what's out, about the price being in there, about the closing dates missing, about the description not being anything other than Tracy's hotel. All that stuff would still be considered. Plus, we could say, well, the lawyers drafted the written agreement and that we had a formal signing, you and I, and that we can look at this and go, well, one of the oddities of a modern jurisdiction is that a court, even in assessing how to categorize the written contract, can say, well, we're going to look at this extrinsic evidence too to see what purpose it serves, this oral agreement. And the extrinsic evidence here and keep in mind, the court's only at this point considering for the purpose of going, well, maybe that sheds some light on how we should think about how much weight this writing should be, whether it's final and complete. And here the extrinsic evidence would clarify some of what's going on, although it doesn't necessarily mean that we're not saying, oh, it's definitely coming in, but I don't think you land in any different place. I don't think the surrounding circumstances put us suddenly over to a total integration or not integrated at all. I think you land in basically the same place. So that means we have to go to the next step, which is to say, okay, we've decided, we have a parole evidence rule issue. We are assessing the writing to say, is it final and is it complete? And what level of integration is it, or category or bucket? And we said that it is a partial integration. Okay, does that mean you can or cannot put in your evidence of the oral agreement? And how does a court determine that? Well, they're going to look at the level of integration that was determined. We just said partial. We'll walk through that in a second. But we're also going to look at, if we look at this extrinsic evidence, all we mean by extrinsic evidence is that we like to use really big words. But it also means that with extrinsic, we're saying just outside of the written agreement, that the evidence that you are offering, and if we were saying not just this hypothetical we're considering as in this lesson, but broadly, it's any time a party is offering evidence of something external to the agreement, we call that extrinsic evidence. Here, that you're offering extrinsic evidence because it's something outside the written agreement, evidence of an oral agreement, which could just be you on the stand testifying about the oral conversation. Okay, keep in mind, that's what the kind of thing we're talking about. And here, the other question the court will need to consider and going, should we allow this in or not, is not only the level of integration that we just determined in the previous step, but also when we look at this evidence, is it consistent or inconsistent with the rest of the agreement? Is it consistent or inconsistent with the written agreement? Right? The consistent or inconsistent with the written agreement. So does it contradict? Or is it a consistent additional term? So how do we combine that? Well, let's look at it. If you have a total integration, right? If something is total integrated, we would go, what's the rule? If something is a total integration, if that's what the court arrived in the previous step, then the parole evidence rule says no contradictory evidence can come in. So nothing that contradicts the writing, the terms of the writing, and additionally, no consistent additional terms can come in either. So if it's a total integration, the court is saying that written agreement was intended to be the final and complete expression of the parties' agreement. We are not letting in any extrinsic evidence at all to cast, doubt or to try to change it, right? To try to add or change it. We're not allowing it. So on this end of the spectrum, the total integration, the answer is no extrinsic evidence is coming in. The parole evidence rule bars that evidence from coming in. But if we're in the middle, if we go, it's a partial integration, meaning, which is what we said in our case, and we'll apply it to our facts in a second. But if it's a partial integration, meaning what's there is complete, or what's there is final, but not complete, then the court will say, you still can't contradict what is there. You cannot put in extrinsic evidence to contradict the terms that are in the writing. However, if it's a consistent, meaning non-contradictory, consistent additional term, then it can come in. It can. And so we're allowing this extrinsic evidence, assuming it's a consistent additional term. You're offering the evidence to show here is a consistent additional term, not to contradict what's there. If the court goes, that's not integrated at all, meaning that that writing wasn't intended to be a final expression of anything, then all bets are off. We're on the total opposite end from total integration. Everything's coming in. You can contradict it and you can add consistent additional terms because we don't think the writing needs to be treated as sacrosanct. It's nothing special. Right? There's nothing about it that is particularly worth any weight. So we would allow the evidence to come in. So on each extreme, the answer is really straightforward, right? If we come out of the analysis going, it's a total integration, then we know that evidence ain't coming in. And if we come out of our analysis and go, that's no integration, then we know that evidence is coming in, at least as far as the parole evidence rule is concerned. And with partial integration, then that's where we have to go. Is that evidence consistent or inconsistent with what's in the written agreement? So let's talk about that. So with a partial integration then, and we're applying it, remember we said the written agreement between you and I about this purchase and sale of the hotel for $2 million, that was a partial, and that written agreement was partially integrated. Meaning what? We said that means no evidence can come in that will contradict it, the terms that are in it, but you can have consistent additional terms. So we can supplement it with consistent additional terms. So what are those consistent additional terms? Well, here, the furniture term is a consistent additional term, right? Because the written agreement doesn't say anything one way or the other. It is silent about the furniture. So this would be considered a consistent additional term. That's fine. It would be allowed to come in. So your evidence of the oral agreement, as far as it concerns the furniture, could come in. But as to the change in the payment term, the writing says 6 months. And you're going, what? There was an oral agreement that said 1 year. That directly contradicts. And by contradict, keep in mind, we're not saying it has to negative it out. It doesn't have to be it is the non-6 months provision. No, it's like if what it's doing is changing the term, in a way that is not at all consistent, then that's contradiction. Here, saying the payment term is actually double, it's actually a year rather than 6 months, is contradicting exactly what the written agreement says. So what then should we conclude from this? Well, that means that the consistent additional term, the one that doesn't contradict what's in the partially integrated written agreement that you and I have, that's coming in. It's admissible. But the evidence about the 1 year payment time period would not be admissible. It would not come in. So that's where we land. And we have to keep in mind, though, if something is not admissible, if all of the evidence being offered or some portion of of what's being offered is not admissible, then we need to look at the exceptions. We need to go to this last step and go, well, even though this is a partially integrated written contract and this is contradictory evidence, should it be allowed to come in? And there are 5 exceptions here. And the way to think about these exceptions is you need to back up a second, and we'll walk through these. I'm not going to go into excruciating detail, although I will talk through them, because some of these concepts we're going to hit more in future lessons. But know that when we're talking about the parole evidence rule, that what you want to think here, particularly with these 5 exceptions, that you want to ask yourself, for what purpose is this party offering this evidence? What is the purpose or the reason they are offering this evidence? So in our example, it would be, why are you offering this evidence? Because almost every single one of these exceptions there is a purpose that is different than what the parole evidence rule was intended to capture. And by that I mean, and hopefully this is clear as we just went through the basics of the rule, is keep in mind that that rule is triggered and applies in situations where the party offering the evidence, which was you in our example, is offering it to say either here is an additional term to the contract, or here is a different term to the contract. So here, this evidence that I am offering for the purpose of adding a term to our contract about the hotel, or I am changing a term in the contract about the hotel. That's what the parole evidence rule is aimed at and concerned about. Whereas all of these exceptions, the party is not offering the evidence for that purpose. They are not offering the evidence to add a term or to change a term of the agreement. In the hotel example, you were offering the one term to add the term of the furniture is being sold along with the hotel. And you were offering the other term to say, well, actually, the payment term was not 6 months, but 1 year. Those are precisely the 2 things the parole evidence rule is aimed at. But if the evidence instead is being offered by the party for the purpose of interpreting the agreement, meaning that they are offering it not to add a term, not to change a term, but in order to explain what was intended by the parties, to say, let me, court, give you some evidence that shows what we intended when we said spring 2024 was the completion, the first day of spring 2024 was the completion date. Let me explain what we meant by that term. And so it is saying this is what was intended. Rather than adding a term or changing a term, it's explaining it. And I'll say more about interpretation in a second. But then a subsequent agreement. So subsequent agreement typically means that the parties had a contract. Like they say, you and I, we entered into an agreement, and then later we may, let's say after we executed the written agreement, we orally agreed to something, meaning we modified it. We orally agreed to modify our agreement. That is subsequent to the written agreement. So subsequent agreement means subsequent to the execution of the written agreement. Because again, the parole evidence rule is saying, okay, the parties were negotiating, and then they put everything in writing and executed that writing. And if something isn't in there, we're real concerned if someone's going to offer evidence about it, because surely if they wanted to put it in their contract, they would have put it in the writing, and they didn't. So that seems like it was purposely excluded. That concern is not here if what's going on is the party is offering evidence of something that was allegedly agreed to afterwards, subsequent to the written contract. That is typically a contract modification. So the other thing is, you could be offering evidence for the purpose, again, not of adding a term, not of changing a term to the contract, but saying, I'm offering this evidence to show that some defense I'm offering it to prove a defense, right? To prove misrepresentation, to prove mistake, to prove unconscionability, any of these other defenses to formation that we have covered, that those you can put in that evidence, even though it is, quote, extrinsic to the written agreement or external to it, you can still do that. It can be used to show a collateral agreement, meaning that there was some other agreement that was made at the same time with its own offer, acceptance, consideration. It is collateral to or supplemental to the contract that was agreed to. And so again, the party is not offering the evidence to add or change the terms of the main agreement like the hotel agreement, but is saying, no, we also agreed to this other thing, that's his own little contract, that they agreed that they would also continue to provide landscaping services for the hotel grounds for the next year after the sale. And yeah, it's not in the writing, but we separately agreed to that, and I agreed to pay an additional $50,000 for that to occur. And so there was this collateral agreement. Is it about the same subject matter? Yeah, it relates to the hotel, or at least it relates to that subject matter. But I ain't trying to change the terms of the agreement. I'm just trying to say there's a collateral agreement over here. Or you might say, and this is the one that for a lot of people isn't immediately clear to them, which is this. Again, this is a situation where the party is not offering the evidence to change the terms or to add terms, but what it's doing is it's saying, we agreed that this written agreement about the hotel is that it wouldn't have any legal validity at all, that it wouldn't be legally effective, it wouldn't be legally enforceable or valid unless and until this event occurred. And it could be something as simple as, we agreed unless and until this was signed off on by my lawyer that as being A-okay, that it wouldn't be given effect. So it's like you and I sit down, we execute a written agreement, and then we orally agree that, well, just remember, this isn't anything. It has no legal effect unless my lawyer or unless my boss or unless whatever, somebody signs off on it, or unless this thing occurs, that then it won't be given any legal validity. So the condition there is, it's evidence saying, I'm not trying to change the terms of what's in the writing. I'm just saying, we agreed this thing meant nothing legally unless and until whatever event had to occur. So that's what we mean there with that last exception. So if we kind of bring it all together, right, and say, what does this look like? We're asking, one, is there a parole evidence rule issue at all? And we said the typical fact pattern, right, that you have a written agreement, there's a dispute that arises, then one of the parties is saying, well, everything we agreed to is in the writing, and the other party's going, well, there were also this oral agreement that we made, or also there were things in this, right? It doesn't have to be oral, right? It could be, oh no, we also sent this letter, we had this letter we talked about, or whatever, this email exchange or this text exchange, whatever it is, that is evidence you're trying to get in of some additional or different term. And then we're looking and going, the court's going, okay, and it's doing this why? In order to decide whether the party should be allowed, the party claiming that there are additional or different terms contained in some sort of text or email or in an oral discussion, then the court's going, well, I don't know if that should come in or not because we have a written agreement. So let's look at the writing to decide what did the parties intended to be, that they intended to be the final and complete expression of their agreement. So we're doing that to decide how important is this? How much weight should we give it? Because if they intended it to be final and complete, and we're going to say it's a total integration, that's the most weight we could possibly give it, right? Or is it just nothing? It's just a draft they were kicking around, and therefore it's off here as a not integrated at all, and we don't need to give it much weight at all. So then after we decide, is it total, partial, or not integrated, then we're looking to say, is it admissible? And we said if it's totally, we'll review the specifics in a second, but we're going, is it admissible? Depending on what kind of integration, admissible, what admissible? The evidence that's being offered, right? That of additional or different terms. And then if either all or part of the terms that are being offered are not admissible, you want to go to that last step and go, well, does one of these 5 exceptions apply? So just to bring it home, when we're asking, is it at issue? Then we say a dispute arises, one party's claim. So we have a written agreement, dispute arises, one says all the terms are here. The other party goes, no, they're somewhere else. And then that party is offering evidence to show of this additional or different contract term, and the court then has to go to the integration step, right? Let's look at the writing. Is it integrated? If so, what kind? Right? Then the judge looking at this, we said there are 2 approaches. There's a classic approach and a modern approach. Under a classic approach, she's going to look at the written contract only, limit herself to the 4 corners of the agreement to make this decision. In a modern jurisdiction, she's going to look at the entire context surrounding the written agreement to decide what? To categorize it as either complete, partial, or not integrated. Remember, complete means that it is both the final expression of the agreement and includes all the terms. Partial means what's there, the terms that are there, that's the final expression of them. That's what the parties intended as the final expression of those terms, but doesn't include all the terms. Then not integrated means it wasn't intended to be a final expression of anything. So then if it is, after the judges categorize it, we must go to the next step to say, what is admissible? We said if there is a complete integration, partial integration, not integrated. If it's a complete integration, then that parole evidence, as extrinsic evidence, is out. So if it's partially integrated, then we said we've got to ask ourselves, is that evidence of additional or different terms, are those consistent or inconsistent with what's in the written agreement? If they are inconsistent, if they're consistent, they come in, right? Consistent additional terms. If they're inconsistent, then they're out. If it's not integrated, everything's coming in, right? So we complete integration and no integration on total opposite ends of the spectrum. So with any of these, remember, anything that is refused, we need to ask, well, does it fall within one of these exceptions? And remember, it's real important here. Ooh, I spoiled it, and then I take it all away. Obviously, I misorganized my slides there. So here, exceptions. So remember, with interpretation, we're saying the evidence is being offered by the party not to add a term, not to change a term, but to explain it. And it's important to understand that you can only do that if you're under the common law, if there's an ambiguity that needs explaining. So the common law insists that you need an ambiguity in order to be able to say, my purpose in putting this evidence in is to interpret. If the common law says, well, there's nothing that needs interpreting or explaining, then that can't be why you're putting it in. The UCC takes a much more liberal approach, meaning that you don't need an ambiguity as long as it's true that you're putting it in for the purpose of interpretation. Now, one thing to note here, when we are finding an ambiguity, if we're in a common law context and we are trying to asking ourselves, is there an ambiguity? Well, remember there were 2 approaches to determining whether there was an integration, a modern approach and a classic approach. The same is true when a court looks to determine if the terms of the contract are ambiguous. If you're in a classic jurisdiction, they would only look at the written agreement itself to say, is it ambiguous? Does it appear ambiguous on its face? We call it a patent or patent ambiguity. So is it clear from the face of the agreement? Whereas in a modern approach, you could have an ambiguity based on things outside the written agreement itself, looking at the surrounding circumstances. So it's possible to have a latent ambiguity that you can try to explain away. In the UCC, again, you don't have to worry about that so much. So it can come in as long as you can truthfully say, I'm not adding, I'm not changing, I am explaining. So when the other exception, remember, was a subsequent agreement, meaning after the writing, that's typically the execution of the written agreement, that typically means it is a modification. Then a formation defense, we've covered a lot of those. Anytime you're offering the evidence for that purpose, parole evidence rule is not a problem. Then a collateral agreement or supplemental, again, you're not trying to add or change the terms of the agreement at issue. You're saying there is some sort of other agreement on the side here that is relevant for this reason or that reason. So, and then you could have evidence of an oral condition precedent there, and I explained that already. So that is that. I know it's a lot, and it can feel complicated, but I think if you back up and kind of get a handle on understanding the actual scenario that exists and why this problem arises, it makes a lot more sense. And if you're thinking about why is the party offering that evidence, because that's going to determine, should this just go right? Does it fit right into an exception? Or is this the kind of thing where I need to be concerned about? Like the parole evidence rules genuinely could be a bar here. So let's leave it at that for this. So as always, if you found that helpful, please do like and subscribe. Hitting the thumbs up, hitting the subscribe button is helpful. And I know you've never heard that in any YouTube video ever, but I figured, I'd be unique and mention it. So then also, thanks very much, and I will be in touch with more lessons in the future. Bye.